Another day, another story with your friendly AI lawyer. Facts. Minors, represented by their parents, and the Philippine Ecological Network, Inc. Penay filed a class suit against the Secretary of the Department of Environment and Natural Resources, DENR, and several Timber License Agreement, TLA, holders. The plaintiffs sought to cancel all existing TLAs and to prohibit the issuance of new ones due to the misappropriation and impairment of Philippine rainforests. The defendant filed a motion to dismiss the complaint, arguing that the plaintiffs have no cause of action against him and that the issue raised is a political question. The trial court granted the motion to dismiss, ruling that the complaint states no cause of action and that granting the relief prayed for would result in the impairment of contracts. The plaintiffs filed a special civil action for certiorari, asking the court to rescind and set aside the dismissal order on the ground that the respondent judge gravely abused his discretion in dismissing the action. Issues. Whether or not the plaintiffs have a cause of action to prevent the continued deforestation of the country's vital life support systems and the rape of Mother Earth. Whether or not the issue raised is a political question. 3. Whether or not the cancellation of TLAs would result in the impairment of contracts. Ruling. The Supreme Court rules in favor of the petitioners and against the trial court's order, finding that it was issued with grave abuse of discretion amounting to lack of jurisdiction. The court finds that the complaint focuses on the right to a balanced and healthful ecology, which is explicitly provided for in the Constitution, and that the petitioners have standing to sue on behalf of future generations. The court also notes that the DENR is mandated to ensure the sustainable use, development, management, renewal, and conservation of the country's natural resources, including forests, and that TLAs can be revoked when the public interest requires it. Discussion on legal doctrines applied. The case involves the violation of the right to a balanced and healthful ecology, which is protected by the DENR's duty under EO number 192 and the Administrative Code of 1987. The granting of timber license agreements, TLAs, is claimed to have been done with grave abuse of discretion, and the petitioners argue that their right to a balanced and healthful ecology has been violated. A cause of action is present, as the legal right of the plaintiff, correlative obligation of the defendant, and act or omission of the defendant in violation of said legal right are all present. The political question doctrine is not applicable in this case, as it involves the enforcement of a right vis-a-vis policies already formulated and expressed in legislation. The non-impairment of contracts clause found in the Constitution is also not applicable, as timber licenses are not contracts, and even if they were, the non-impairment clause must yield to the police power of the state. The grantees of the TLAs must be included as party defendants, as they are indispensable parties in the cancellation of the TLAs. Overall, the statements under the introductory affirmative allegations and the specific averments under the subheading cause of action are adequate enough to show the claimed violation of the petitioner's rights, and they may be granted the reliefs prayed for. Thanks for watching. Please subscribe to my channel.